Hi everyone, welcome to the Lawcast. Melanie Thorley here again, and this is Christy Santana sitting in. Today we're going to be talking about a brand new case that came out. Chris and I have just had a brief conversation about whether it fits into the Chris's Commission Crazies. And I'm thinking that maybe it does, but we'll have a bit of a chat about this, shall we?
Yeah, sure. Why don't you hit us off with firstly the facts? So what happened?
Yes, I really like this. So what? so the case is really long for a start. So we need to make sure that everybody understands that for a decision from the Commission, it's like twice as long as any other case out there. And the Commissioner said specifically in the case that he was going to go over and over and over and over and over. And he does just that. I assume it's a he, actually. I'm saying the word.
You're generalizing, but
I'm generalizing.
But you're right. The case almost replicates a lot of the evidence and explores it on a really, really deep level.
Yeah. So look, at a high level, what happened was this Qantas trainer was training a bunch of people, and it looks like they were training approximately 5 people in the morning and 8 people in the afternoon.
Yes. And
at some point in the middle of the morning session, the trainer was trying to demonstrate how to see if someone was under distress. And it goes into some medical evidence about what that might look like, and it's all about oxygen, I think, from the case memory.
So this is all training for, I take it, flight crew to deal with different situations that can happen on a plane, like for example, someone choking, or they're having a heart attack, or they're having a mental breakdown or something.
Yeah. And I'm gonna walk through the case, so jump in when you want to say something, Chris, but I just think this is really interesting. So first of all, not everybody who was present at these training sessions were interviewed. And I think that is weird, and I'm not sure why. It could be because they were no longer employees. I don't know. That doesn't really go into why. And none of the participants of this training session gave evidence.
Right.
They weren't there. They just didn't give evidence. And the only person that gave evidence was the complainant. And they have purposefully kept the complainant's name out of this. They said it was somebody who's been there since the 90s or in some type of management position. They attended this training session, and that is all they're going to do to identify this complainant. I'm going to assume that everybody who was at the training session knew who this person was, because one of the things they say is that she wasn't wearing a uniform, and she was the only one there not wearing Qantas uniform. So I'm going to just go back to the fact that none of the participants of this course were actually interviewed. And at one point, the council said the Commission knows exactly what those witnesses would have said had they been called.
That's a brave statement.
The Commissioner just goes nuts.
I think that's going a little bit further than saying that, given that they were not called, there's a presumption that their evidence would have been against the interest of Qantas. I think that's one way of saying it, but sure.
Well, they talk about that a little bit. The Commissioner, this is where I think it gets into the Commission crazies. Not that the Commissioner is crazy, but the way the Commissioner had to deal with all this is rather entertaining. He says none of the participants personally gave evidence in the hearing of the Commission. To the extent that repeated references were made in the proceeding to the participants' investigation statements, neither the participants' investigation statements nor the parties' submissions concerning those statements assisted me particularly, if at all, in the resolution of the contested versions and characteristics of the events given directly by the applicant and the complainant in their own evidence. And then he says, I reject the respondent's submission that I would know what the participants' evidence would have been, let alone exactly had any or all of them given evidence. Assuredly, I do not know what would have been elicited by the scrutiny of cross-examination had evidence in fact been in the proceedings to any of the participants. He just goes on and on. In videos such as some imponderables, for example, such as how the participant seated in the third row behind a complainant may have seen the face mask wearing complainant blush at the time the applicant was looking at the complainant's chest. The participants' versions of the investigation were characterised, for example, some significantly inconsistent or incompatible recollections. So he's just, what the commissioner did is he just said, dude, you can't say that because there's a whole pile of stuff going on here that we can't find out about.
Well, exactly. By them not being called, not only are the commission not able to explore in more depth certain points that may have been left out in there. I take it these are statements to the investigator or some interview notes or, things like that.
That's right. So only 4 out of 5 of the morning participants were interviewed, and then only 2 out of the afternoon ones were interviewed.
Yeah.
So the interviewer made notes and then reduced those notes into a statement, and that's what was submitted, from what I understand. Fascinating stuff. So we've got this situation where some guy has been terminated. He's running an unfair dismissal, and they don't think to put these people on the stand.
I think you're asking for trouble, because one of the things as well is there's a very big difference between giving evidence or giving your statement, if you want to call it that, in the context of a workplace investigation, as opposed to in cross-examination before a commission, where there is every chance that evidence changes, and in the broad light of day, and you can also explore in far more depth than I suspect happens in many investigations. For example, you were sitting in the 4th row, there was 3 people in front of you, she was facing the other way, how could you know that she was blushing? Things like that.
That's right. And the investigator may not have had the foresight to ask that question, or didn't need to, based on the investigation stuff. All they wanted was that person's account. So the commissioner, this case unravels, as and it's a lot of paragraphs long. So sort of after the commissioner is a little bit wary of accepting the evidence of these participants in their notation only, they go on to talk about what the actual complainant was wearing, and this cracks me up, because obviously it makes sense, because we're talking about someone who's staring at somebody's chest, but it says
we'll take it back as to what actually happened at these training sessions. What was the allegations?
Right, the allegation was that this trainer was stared into some female's eyes for up to 10 seconds and then stared at her chest for up to 10 seconds, and it made her feel uncomfortable, and she said something like, can I go now? Or,
yeah, I think it was, can I move on? Can we move on?
Can we move on? Yeah. And it came up that it was apparently important what she was wearing. And since the complainant was wearing glasses as well as a face mask, and unlike all other uniform participants, the complainant was not wearing a Qantas uniform. The complainant said in her written reply that she was not informed of the number of training participants when the applicant was not present, but she was not in uniform because she could not fit into her uniform. I'm not even sure how that's relevant, but it's in there. On the upper part of her body, the complainant was wearing a T-shirt, with which I gather from the evidence had some form of scooped neckline, which meant the complainant's skin on the part of her upper thorax and upper chest area was visible from the neckline of the T-shirt. I just think it's not often in these commission decisions do we hear such detail of
accounts of this type of nature, but nevertheless they thought that was relevant, as to, because I suppose in the applicant's defense, I know that they were claiming that, one, they weren't staring, but they certainly appeared to agree that they were at least looking at her upper torso. But in the context of, I believe it was trying to tell whether someone was dilating, their chest was, whether they were breathing or not.
This is the applicant's version. He was trying to show, they were in the medical part of this training session, and he says it was using relevant PowerPoint slides that led to a discussion about what aviation medical involves, including the role of the first aider to promote, preserve and protect patients. And apparently effects of altitude like hypoxia, being the lack of oxygenated blood to the brain, is statistically the most common cause of illness. And then he asks what the signs and symptoms are, and you see the signs and symptoms. The signs are what you see, and the symptoms of what they say. You don't ask a person what your signs and symptoms are. That's just silly. So he's trying to train them into trying to do this.
So reading their body rather than asking them questions, because if they've got hypoxia, they're probably kind of...
They're not going to answer. And then there was a practical demonstration where he picked some rando out of the class, and he said directly in front of where the applicant was, the complainant was sitting directly in front of where the applicant was standing. The applicant said, "You look at the person, ask how you're going." The applicant looked at the complainant's face and said, "How you're going," as the demonstration. The applicant could not tell anything from the complainant's face because she was wearing glasses and a face mask, and they were 1.5 metres apart. The applicant then looked at the complainant's chest area to process breathing, and he waited for a duration of a breath, which estimated took him about 2 to 3 seconds, then looked up and said, "Yes, you are observing skin colour of pale red." And then the complainant said, "Can we just move on?" And apparently the complainant made a really lame joke at some point, and in terms of how the colour of this person's skin was also similar to the colour of somebody else's top or something like that. The applicant continued instructing the class and said, "You observe sweaty, dry skin, a breathing rate, yes. Do you have any allergies?" The person may say no, but you might be thinking yes because the skin is red. So you obviously noticed a change, but didn't really associate that with embarrassment. So we've got this kind of concept where some lady is wearing a scooping t-shirt, and she's going to be an older woman because she's been there since the 90s. This is the first time that she's participated in this particular session with this particular person. He's just pulled some rando out of the group, and it happened to be her, and he's then, staring at her chest. But the allegations are what, so now we've got a commissioner who's going deeply into what's actually happening here. And the allegations I find are, look, I think Qantas did quite a good job when it came to the allegations. They particularised them well. There was things about leaned towards her, stared into her eyes, lowered his eyes and looked at the complainant's chest, then looked at her chest for 10 to 20 seconds, and they either substantiated or didn't substantiate, or confirmed or not confirmed these allegations. And I actually quite liked it, but there is a critical problem here.
I know that the commissioner was hugely scathing of the investigation itself, and the way, not so much the way it was handled, I suppose, but the path it took, I think, is probably a better way of putting it. I believe the commission was scathing on the fact that the investigator failed to take into account that what we're talking about here is sexual harassment, and she failed to take into account the objective nature of a sexual harassment.
That's right.
Dismissal. Focused way too much on how that particular complainant felt about it, and the report seems to go at length about what happened after these incidents. So You know, I think she went back to the bathroom. She felt very uncomfortable. She was crying. She felt very distressed thereafter, felt really embarrassed, which is all very kind of interesting for a workplace side, if you want to put it that way. But in the context of an investigation, is largely irrelevant about how she felt about it.
Yeah, I think it's like they were trying to answer the question, did sexual harassment occur?
Yeah.
Without looking at the two elements. And it's really easy to fall into this trap of this kind of, oh, he looked at her chest, it must be sexual harassment, as opposed to what is actually happening here. And whether or not the participants of the course could have helped by being objective bystanders, essentially, in a way. They weren't put on stand, so the commissioner couldn't find out about what they thought of the thing at the time.
Incident. Yeah.
No one asked them, for instance, did it all look like it was part of the show?
And one of the problems is they were really the only people that would be able to give evidence in a way that isn't self-serving, because the complainant is self-serving, so is the investigator, because their neck is on the line in many ways, and of course the applicant is as well. These innocent bystanders are only the ones who are really going to be able to give an objective account of what happened. And you're right, whether it, because some of the other evidence was, you know, why did he pick her out? You know, why did he make the joke? Why did the thing end? I mean, really, only bystanders are going to be able to kind of give a bit of an inkling into what happened.
And we just don't have any of that evidence. In fact, the commission basically just said, yeah, we've got some witness statements. Hang on a sec, my puppies are running around like idiots, and one of them has stitches, so I've just got to stop that for a moment. Hang on. See, water, back inside, come on. No. And you go. And you. I know it's very exciting being a little puppy. Stop running around. Really stop running around. Oh, goodness. Oh, sorry. You can sit on my lap for a bit. It's got like 10 stitches in this. Sorry?
I can tell you that my long-standing issue with a dog near me is also currently happening. So if you can hear a dog barking in the background, then
it's terrible. Seymour has got about 10 stitches in his stomach at the moment, and he's too active for, and it only happened yesterday, and he's too active for words, so I have to try and calm him down a little bit. It's a shame they can't give him drugs to keep him drowsy or something.
Probably can, but it'd be quite unethical, I imagine.
True.
But going back to
the case. So yeah,
yes.
I just think so yeah, the investigator probably could have done better. And what was also really quite, I guess this happens a lot because we see it where our clients don't like to use the actual swear word, or you know, they didn't actually use the word breast at any point in the investigation.
No.
They used chest the whole time, and then breast came out in this in the submissions and in the matter, and yeah, I think it was blindsided because he was thinking chest the whole time.
Well, one of the problems in this particular case is they're also not flushing out the real issue, because of course he's going to admit to staring at or looking at her chest, I suppose, because he had to. It was part of the whole act. What the real problem would have been is whether he was just staring at her breasts, which are fundamentally different. And they needed to have actually flushed that out, the two differences. You know, are you saying it's chest or are you saying it's breast? and they just didn't really put it to it. And yeah, you're right. We see it all the time where, for some polite reason, our clients don't want to say, the F word or whatever.
Swearing, penis. There's all these words that our clients essentially feel too embarrassed to put into a document, to write into something. And I think the investigator actually fell into that trap as well. They should have just, if the complaint was that they were staring at her boobs, which is what breast is, then they should just called it that. And yes, it's all very well to put the genie back in the bottle later and start calling it something else. But I think, and that was part of the issue when it came to the given reasons in the procedural part of it. So when people are dismissed, an unfair dismissal considers harshness, and part of the criteria for harshness is whether they were notified of the reasons. And given a chance to respond, and all he was notified is that he was staring at her chest, and at no point was he given the allegation that he was staring at her breasts.
Yep.
And I think there's a massive failure in really getting to the crux of the matter, and it was probably always going to fail once we got to that point.
Well, they were doomed. I think the reason I really like this case is it's a cautionary tale about how an investigation should be undertaken, and that sometimes I think they made two fundamental mistakes. One, I think they had an outcome that they wanted to achieve prior to the investigation, so they went in it without an open mind, and picked out the information that they wanted to, as in put a lot of emphasis into that subjective nature without really considering some of the objective sides to it, and probably didn't give enough weight or consideration to the applicant's side of events, and the potential that, maybe it was just part of the training. And then I think secondly, just maybe being not independent enough, and not in that sort of way that they know each other or there's a conflict of interest or something like that, but just not taking that step back and seeing what's really going on. And I imagine Qantas is one of those large organizations, and sexual harassment's in the forefront of every HR's and every investigator's mind at the moment. It's one of the biggest issues that's happening in Australia in most workplaces, and just potentially looking too closely into things.
Yeah, it's really hard, isn't it? Because as an investigator, what you want to do is get to the bottom of something, and your job is to either figure out whether it happened or it didn't happen. And you've got to kind of stick your neck out at some point and say, on the balance of probabilities, it did or it didn't, or I can absolutely substantiate it or I can't substantiate it. And I wonder if the actual fact is someone should have said, a set of legal eyes perhaps should have gone over the investigation and said, well, hang on here, this is all about the subjective element. What the investigator has failed to do is, and maybe the investigator doesn't need to deal with the objective part. Maybe the investigator just has to say what they interviewed and what they did, and it's up to somebody else to make a decision about how to interpret that information. But you're right, at the end of the day, no one looked at the objective element. This guy was screwed from the moment the Me Too campaign came out 3-4 years ago. Do you know what I mean? It seems like...
No, I 100% agree. I think in days gone past, these allegations might have been unsubstantiated or cannot be substantiated, a sort of middle ground. And I think in many respects, I feel sorry for this investigator, because there's more pressure to substantiate this particular type of case.
Yeah, we need a balance in the world, and we don't have it yet. It's like a while ago, any man that was at a playground was being criminalised as a paedophile. And you look at that and go, What, so every guy who has a kid, who takes his kid to the park, needs to feel worried that if he's watching the children, that someone's sitting there going, oh, that guy's a creepo, he shouldn't be watching kids.
Mm.
And it's a very similar situation in this particular space. He was already doomed. This woman was upset that he was looking at her chest, breasts, whatever, and he was already doomed from the start. But at the end of the day, the commissioner sifted through all this and gave him his job back.
Yeah, he's one of the very few that got his job back. I mean, Qantas is probably only one of 20 companies in Australia, and it really probably is only about 20, if that can actually, reinstatement is actually viable option. Because you have to be, I suppose for everyone out there, reinstatement is the primary remedy for an unfair dismissal, but as in they'll look to reinstate someone before they give compensation. However, it is rare.
Yes.
Because there is almost always a breakdown in trust and confidence between the parties, and usually it's mutual.
Yes.
Usually no one's actually really arguing about it, because you know what, the employer doesn't want to be there, the employer doesn't want them there.
And that's completely understandable when we think about they've just dragged each other through a very incredibly expensive, very lengthy. This started in January last year. Litigation, and who the hell wants to be around these people after that? Just a moment. Okay, you two, stop being up to mischief. Oh, it's the cat.
Reinstatement's actually one of the interesting areas where I think it's one of the only areas where the courts and commissions actually look at the relationship of the parties after a litigation, as in after liability has been formed, and they'll take into account the case itself, like the proceedings themselves, and whether that caused a breakdown in trust and confidence. So just an kind of interesting thing. But you're right, Qantas is like, them, Telstra maybe as well, where the organisation is so large that you can put the person back into an organisation and they probably will never come into contact with any of the people involved.
Yeah, it's just a fascinating situation. I really like this case, and I do think it fits into a Christmas Commission Crazies. Not because the situation of staring at a woman's breast is unusual, but because the poor commissioner had to go through and describe what the complainant was wearing. They had to go through and talk about why the witnesses material couldn't really be used in the, just all these kind of weird things that all came up in this case that they don't come up very often. It's not very often a commissioner disregards all the testimony of the other people that were in the room at the time.
Well, I mean, I'm interested to know why. I mean, we'll never know.
Yeah.
But, I'm really interested to know why. And you're right, maybe it is because some of them aren't employees anymore, and we actually see that all the time. And I think it's an absolute warning for employers to take that type of approach, and you really want to make sure that you're at least getting other evidence from. If you don't want to go to the time and effort to interview former employees, then you better hope that the ones you do interview can provide that same evidence, because the commission's not going to care about that.
No, and the courts don't either.
They're looking for truth, and if you could have and chose not to get that evidence, then you do it at your own mercy. Because they, similar to this case, they could have given fundamental evidence which could have helped your case or hindered it. But the likely thing is that there's going to be, the fact that they weren't giving evidence is likely to be construed against you.
Yeah, it is an interesting one. The reason why we're talking about the Qantas case today is not just because it's a funny case, but because actually one of our clients
gave us a shout out, said they wanted us to talk about it. So
wanted us to talk about it. So here we are talking about it, and actually I think it's a good one. And yes, Chris, it's not a mad one about a budgie, a galah, sorry, or a mental one where someone's getting punched out. But I think
well, the reason I don't, just as a kind of to tie this all up. The reason I don't think it falls between my CCC cases is everything that happened there was completely, in many ways, reasonable in the circumstances that they found themselves in, and there were genuine mistakes, not someone who's just gone. It's a mistake that you can see people making, not just someone who's gone off the walls, kazam, just complete ignorance and complete almost disregard for the law.
Yeah, okay. Well, perhaps next time we can come up with one that fits.
Oh, there's enough of them. I've got enough up the sleeve to do that segment for about another year or two.
Well, apologies then today for bringing up a case that perhaps fits the criteria, but we did have a client who wanted us to talk about this one today. I really like it.
Shout out to them.
Yes, shout out to them. I really like this one because I think it shows how easily you think a rock solid case can turn on you as well. Qantas would have thought, easy, we've got this guy, we're going to totally win this, and here he is getting reinstated. So I think my pets also want me to leave. Yeah, so that's us for today, I guess. Is there anything else you wanted to?
No, that's everything for me. We will see everyone in a couple of weeks, and we'll talk about the next crazy case that we've got.
Brilliant.
Okay. You're kind of taking up half the screen. That sort of Pet's half screen.
I'm doing my best here to stay in. Thank you everyone for watching and listening to the Lawcast. We'll be back in a couple of weeks' time, closer, I think, to Easter, in fact. Yes. So that'll be fun. And yeah, everyone, have a great weekend.
Yeah. All right. See you, everyone.
See you later.